3, 2, 1, start. Class 4 is income derived from business and the source is business. Class 5 is professional earnings and the source is profession, which includes a vocation by reason of section 10 subsection within bracket 1 of the Act, which provides that the tax under the head professional earnings shall be in respect of the profits of any profession or vocation. And class 6 is income derived from other sources and the source is obviously other sources. Stop. Therefore, if one were to determine the source of income on which tax was chargeable, and that is what one is required to do for the purpose of ascertaining whether the condition precedent to exemption being obtained under section 25 within bracket 3 is satisfied, then clearly tax is charged on business only under class 5 and 4 and on profession or vocation under class 5 enumerated in section 5 of the Act. Stop. This appears to me to lead to a very important consequence. Stop. Since the object of section 25 within bracket 3 was indisputably to grant relief in respect of double taxation of the same income, the relief could only be in respect of the same class of income on which tax was charged twice, that is, income charged under the corresponding classes which have been remanded renamed heads in section 6 of the Act of 1922 and the corresponding heads in section 6 of the Act of 1922 were 4 business and 5 professional earnings. Stop. Therefore, when section 25 subsection within bracket 3 provides that no tax shall be paid in respect of the income, profits and gains of business, profession or vocation, it appears to me that it can only mean that no tax shall be payable on income falling under the two heads which I have just referred to. Stop. Stanza. Mr. Palkiwala next urges that the exemption attaches to business and is not conferred on an SSC, and from this he seeks to argue that whatever the nature of the income of the business and under whichever head it is taxed, it attracts the exemption. Stop. Now, in a sense, it is true that section 25 within bracket 3 appears to confer an exemption on a business, profession or vocation, but this must be understood in the context of income tax law. Stop. A business, profession or vocation is not the unit of assessment under section income tax law. Stop. The tax is charged on income, profits and gains of the previous year under section 3 of the Act of 1922, but the legislature had to refer to a business, profession or vocation on which tax was charted under the 1918 Act. Stop. Stanza. During the process of establishing its common effluent treatment plant bracket start for short, the CETP bracket close, in the heavy industrial area, the applicant moved an application for obtaining consent to establish and operate the same to the Jodhpur Pradushan Nivaran Trust bracket start for short. The trust bracket close stop. The tentative date of completion of the project was 15th June 2008 stop. According to the applicant, the trust is a body established by its trustees stop. With the sanction and permission from the government, it established a CETP and gave permission to the members like the applicant to discharge effluents into the drain that would be carried to the CETP of the trust and treated there prior to further discharge stop. According to the applicant, it was an arrangement of course not barred by any statutory provision that the industrial units in the RICO heavy industrial area were required to discharge their effluents into the drain, which were to be treated at the CETP established by the trust, for which purpose the membership of the trust was given to the industrial units stop through a common drain. The trade effluents from the industrial units were carried to the CETP of the trust stop. All kinds of discharge, whether acidic or alkaline in nature, were treated at the CETP, thereby minimizing the chances of polluting the environment. Stop stanza. The application of the applicant herein to the trust remained pending for a considerable time, and ultimately wide order dated 8th July 2008 was it rejected by the trust stop. The relevant part of the said order of the trust reads as under stop. Your discharge quantity of effluent shown in the application is not justified, therefore membership is not granted. Stop. Having received the above order, the applicant submitted a representation dated 5th August 2008 to the trust, stating therein that with the same kind of discharge as that of the petitioner's unit, some other units have been given membership and the impugned action was apparently discriminatory. Stop. Over.